Well, hello, everybody. You are not going to believe what I just did. So that's why I'm a couple minutes late. So I have this spray here on my desk that it's supposed to help if your mouth goes dry. It's like, what is it called? It's um, Biotine Dry Mouth Moisturizing Spray, something like that. And I thought I grabbed that and I sprayed my mouth, and all of a sudden it was this shocking, horrible taste. And I realized that what I sprayed was not, in fact, my mouth spray, but I had dried my hair here the other day while I was watching a video. And so it was um, blow dry mist. That's because I straighten the life out of my hair. I have curly hair, but I make it straight most of the time. And so, yeah, I sprayed my mouth full of blow dry mist, Style Assist blow dry mist. It's very, very unpleasant. I do not recommend doing that, and I highly regret it. So, could you guys hold for just a moment? So sorry. Okay, that is really, really gross. So, I hope it passes soon because it's very, very unpleasant. Hello, Ricardo. Thank you so much. He says hi to me and he says hi to all of you wonderful people. Thank you for joining. So, I think you've probably seen the latest filings. There was a request for an extension and a couple of days ago, and then we got Judge Liman's ruling on that too. We are getting very close to the trial, and these filings are an exciting indication to that, because once you start talking pretrial filings, you know you're getting close, and it also means that we're about to have some more documents to look at to pass the time until the trial actually comes. And once you see what they all are, you'll see, and you'll probably agree with me, that it's going to be a lot of fighting. Just like discovery, just like everything, I think we're going to see lots and lots of fighting, lots and lots of things that they're unable to come to a conclusion themselves, and they're going to bring to the court for the court to decide. This tastes really, really bad. I really wish I didn't do that. Anyway, I anticipate that there will be plenty of those things coming through that we'll get a chance to look at. And as we go through the filings today, you're going to see how exciting some of them are going to be. So let me look at my notes. So the reason they asked for this extension is they are prepping for trial as we speak. So what they asked him for is an extension of time, and there was an agreed upon time and then an additional request of time. So the agreed upon time was just a week. So that would mean they need to submit those filings by April the 3rd. The additional time was from the Wayfarer parties, and Blake did not agree to them. She did not consent to this request, but they asked the court anyway. So what they asked for is that instead of setting a specific date, but for it to be 21 days after they get the judge's ruling on these dispositive, oh goodness, every single time. Sorry. Sorry about that. And why they want that is because, as it stands right now, they're preparing to defend every single cause of action that Blake has brought against them. But what they want to do is that whatever it is that the judge may rule out, they no longer have to prepare for those. So what they ask for is whatever day you finish deciding these, then we get 21 days after that. And so the ruling came in, and he did not allow the 21 days. He simply allowed the 1 week. And so those will all be due on April the 3rd, whether he's made the decision or not. So it could be exciting. It could mean nothing. We don't really know. So he can take up to the trial to decide these motions. He doesn't have to give the attorneys extra time. Like, he can say, just prepare your case. You don't need to know, just prepare your case. Or he could be nice and try to give them extra time to prepare. But it could just mean that he's granting most or all of them, so they don't really need to worry. That would be the best case scenario. It could mean that he doesn't care what they want. And as he's just flopped back to the judge that we all saw throughout the whole thing that gave Blake what Blake wanted. We really don't know. I mean, I like to think that it means it's coming soon, and so that they will have plenty of time to prepare. So he's like, don't worry about it. You'll have this time. But we just never know, especially in this court. So I mean, a lot of us have speculated. Some think it means something good, but there's no guarantee. It really, there's no proof that it means one way or the other. It's just a decision that he made. So that is that. But I've been wanting to do this for a while, to go through what these pretrial filings are, because it's exciting. And like I said, you're going to see, we're going to get to see some pretty exciting stuff. So, I want to get this taste out of my mouth. We're going to go through what this is directly from Liman's, his individual practices. So that's something we all have access to. You just have to Google that, and you can see these are his requirements. We've referred to this many, many times ever since he first gave us the court schedule for this case, the case scheduling order. We've been looking at this. So I went through that because his is the one that matters. Any judge will have a list of what they want, but this is all that matters, what he wants, because this is in his court. And then I tried to find samples of everything he asked for so you can see what we're expecting. So the first thing that he mentions is the full caption of the action, and I'm going to lump that together with names of trial counsel because that's not anything super, super interesting. So as we can see with this case, I found one that does have a little change. So a case may have been referred to by other names, and then maybe by the time it gets down to the actual trial, that name changes. And so in this case we're looking at, as you can see, it's Ruby Freeman and Wandria Moss versus Rudolph. This is embarrassing. I can't remember how to say his name correctly. And his brother. So, but when you look down at the case caption, it's been shortened to just one versus the other. And so, like in this case, we also have an interpleader. We have Stephanie Jones because Jen Abel filed to add her a third-party claim. So it's already been decided. We've already been notified that part of the case will be its own separate lawsuit that will come after this one. So that our caption could change too, but that's not something we need to spend a lot of time on. We can see they also asked for the list of names. The one on the left is one of Michael Gottlieb's old filings because he was an attorney on this case. You'll recognize at least one other name, I believe. I think Aaron is on here, Aaron Nathan. Yeah. Because they were on that case. Also Merrill. But I prefer this other style on the other side where they do it how we've been seeing it all along. I think it's just much easier to read and much nicer looking. not surprisingly, that I don't like Michael Gottlieb's style. So those are the first couple of things they have to include. Nothing really super exciting or interesting there. But next, they have to provide a brief statement first by the plaintiff, and what the plaintiff has to put is the basis of subject matter jurisdiction. So they have to state that this court either does or does not have a right to preside over this case. And then each party has to say it because they don't always agree. They, as you'll see this repeated throughout all of it, they have to include citations to all statutes. That's so if they have an issue, and you're going to see an example of one in a moment, they have to tell the court, this is my issue and this is why, because that could be decided not so much with this case, because at this point, they've already decided they're going forth with the case in this court, but what it does is preserve appeal. So if you've gone in and you've said, hey, I do not believe this court has jurisdiction to try this case, but you get stuck with it anyway, later, if you do appeal, you can say, you know what, I never felt this court had a right to preside over this. These were my objections. And then that's right there ready for if there's an appeal, they have all that information. And like everything else, if you don't appeal at the right time, you lose the right to appeal. So you can't just say, oh yeah, this is fine jurisdiction for me, and then turn around and later say, you know what, you had no right to preside over this when you don't like the outcome, because then you do not have it preserved. You cannot use that as a reason to appeal. So this case that I found, I think this is still the one I used as a reference. So the plaintiffs felt that this court does have jurisdiction, and they put their statute of why they think it does, but the defendants do not agree. And so they state why. They say, well, the defendant is a resident of Florida, not New York, and the plaintiffs are citizens of Georgia, which does make me wonder how it ended up there, but I didn't have the time to look into it. I'm sure there was some strange New York reason to drag it all to New York, even though neither the plaintiff nor the defendant reside in New York. So he states the reasons why he does not think so. He cites case law that was decided in the Second Circuit. So they have preserved, it did take place in a New York court, but they preserved their right to appeal. And then we have that intervener does not consent. So that is there. Now, I don't think, yes, some strange New York reason. They do the weirdest stuff in New York. So I don't think anyone in either side of this has, I mean, they've objected to which choice of law will be applied, but I don't think so far there has been anyone outright say, besides Jed Wallace, who is now dismissed from the case, but I don't think anyone left in the Wayfarer parties has had a formal objection to the jurisdiction. So Jed always did. So he ended up not a part of this, but we can guarantee that if he still were, there would definitely be an objection. So that's what that is. Moving on, then we get to a brief summary about the claims for the plaintiffs and the defenses that the party asserts remain to be tried. They also, just like I said, we were going to see this, they also have to include citations to any statutes, anything legally to support those things. And let's see. They also need to identify claims and defenses that were previously asserted, which are not to be tried. So that would be anything that has been dropped or anything that the judge drops, anything that, in these motions that he's discussing or deciding right now, those would be anything he says does not need to proceed to trial. We could put that there, but they should not include any sort of evidence, just your citation to the statutes that legally support your summary. And so I think that's the first bit that will be exciting for us, because we'll get to know what they're still taking. As far as Blake, we know that she already had dropped her emotional distress claim. So not only will there be things that the judge gets rid of, but there could be something that they say, look, Blake, you just can't do this, and that gets dropped. But whatever it is, we're going to get to know which claims are still standing and going ahead to trial. And if the judge has not decided yet, there could be something that they just withdraw. And so that will be interesting news for us at that time. Okay, we can see, here's a sample, and we see first the plaintiff, and the plaintiff begins with that intervener, and they, well, I don't want to spend a lot of time on this case because this case doesn't really matter. This is just as a sample. So the plaintiff says what position they take. They put the statutes, or they can put case law, and then the defense gets a chance to respond and also say their points of view, also quoting the statutes. And then we have the intervener in this case, and so that person gets to say something as well. So that's kind of what to expect, what it's going to look like. But we can see on the first one, there's like numbered 1 and 2, only 2 left. That's not a whole lot. But this case, this particular that I cover there, this guy had a lot of cases against him, and they're not all the same. So even though you're going to see his name over and over again, some of them were settled, some of them were just a tiny little one-day bench trial, and so on. So I just grabbed what served well for each portion of these requirements. So the fifth one is to state a number of trial days that they expect and whether or not they want a jury. So that will be interesting to see as well, how long specifically Blake thinks the trial is going to be, depending on how many witnesses and what all how we'll get to see how strong of a case she thinks she has, depending on the length of time that she chooses that she thinks the trial will last. Okay, this is the response for that particular case, and they only estimated it to be 1 day. It's a really, really simple. It's kind of like a side quest. I told you this guy was sued a lot. He had a lot of cases against him. This one was just a little one, and I chose this one because if you look at it, it says tried without a jury. What in the world does that mean? You need a jury, right? Well, a lot of cases require a jury, but you can choose. And this sort of case, this was a really small one. This was a matter of he had given some property that plaintiffs wanted to take, but before the trial, he says that he gave it to his brother, so it was not in his possession to relinquish. And so that sounds questionable, of course. So there has to be this case about that to come down to, when did you give it to your brother? Did you really give it to your brother? What's going on here? And so since it's not a really big thing, you don't want to drag a jury into the court and go through all of the issues you have to go through to have a jury. And so this is what is called a bench trial. So a bench trial, it progresses through the same as a regular trial. It's got all the parts except for anything that involves a jury. So of course there's no voir dire, which is like the questioning, where you ask the jurors questions to determine who's going to sit on the jury. And then of course there's no jury instructions and all of those kinds of things, but you still have each segment of the actual trial. Now you don't have to worry about things that cannot be said in front of a jury, because this is going to just be decided by the judge. So you present everything to the judge. So it's the actual, as you're going through, you still have witnesses testify, you still have evidence, you still have all of that, all of the parts, the opening, the closing, but it's just for the judge. And so what's interesting about that is because he is not only presiding over the case, he's also the trier of fact. That means he can and probably will interrupt and ask questions of his own. He can ask it of counsel, he can ask it of a witness, because he's the one that will make the decision ultimately in the end. In this case, I seriously doubt that's what they're going to do. I don't think Wayfarer would ever or should ever agree to that. I believe this will be an actual jury trial. So that is where you tell the court, though, officially whether or not you want a jury. And another option, and this will come up later in his list, but it's on this document, so I'm going to talk about it now. Consenting to a magistrate judge. So a magistrate judge, that has come up a few times before in this case. They are a lower level judge. They're almost like an assistant to the federal judges, in the sense that they handle some of the simpler tasks. They take care of things like arraignments. They take care of providing warrants, things like that. And we just saw in this case, we had a magistrate handle the settlement talks. Do you guys remember? We got information about that. So you can, if you don't have a big, serious long case, you can opt to just have a magistrate handle it. But it's not often consented to. Okay, the next thing he requires for people in his courtroom is a joint statement summarizing the nature of the case to be read to potential jurors during jury selection. So, did I have a sample for this? Yes, I do. Okay, it's kind of small, but it's okay. We're not really, we're going to have the actual documents very soon to look at for ourselves, and they will be much, much more interesting. But I just wanted to show you the format so that you know what to expect. So we see first, there is a statement of claims by the plaintiffs, and we can see what they do is go through each cause of action that's still going to remain going ahead into the trial. So for example, the first one here is defamation per se, and then they kind of list out 3 main points that they are going to highlight throughout the trial. And then there is, sorry, that stuff's making my nose run. I hope I didn't breathe it in. That was really, really awful. Then after they go through all of theirs, then defense makes their statement in response to all of that. And this is all going to be for the jury later. But for this case, it's going to be much more juicy than what I have here on the screen. So the next part, I'm not really familiar with this request. And I couldn't find an example. I've not personally come across it in any case I've covered. So usually, because it says a list of people, places, and institutions that are likely to be mentioned during the course of the trial to be read to potential jurors during jury selection. Like I said, I couldn't find a sample to show you. Usually when we see something like this, it's in the voir dire, because any kind of company or person or place that is going to come up in the trial, they don't want any prospective jurors to have any connection to them. So like if they're suing a certain bank, and it's like a local jury, you want to make sure that none of the prospective jurors bank at that bank or have worked at that bank or have relatives who work at the bank. So normally that's where I have seen stuff like this. So this might just be something I'm not familiar with, but usually when it has to do with the jury specifically, that's what you're looking for. You you want to make sure that there is no affiliation with a juror, because that could get really, really messy. That could be a conflict of interest. So I don't have a sample, like I said, for that. I don't know if that's something they provide to each other, so that both of them know to include that in their own voir dire questions, which you'll see in a moment. And maybe that's why I'm not familiar with it, or it's just something that I don't know. Then we have number 8, which is that question for the magistrate, but you've already seen that on that document, and then I explained that to you there, but it just comes up in a different spot in his questions. This one is probably the most exciting so far that we're going to get to see from this list, a list of all trial witnesses. And this will be from both sides. So that is very exciting, because there are a couple I can think of that we're wondering whether or not they will. One of them is possibly Taylor Swift, because just because she was not deposed does not mean she cannot be called as a witness. She was put on Blake's list, which is why she was subpoenaed, because she appeared in Blake's list, even though all of the Blake people love to get on there and say, oh, that evil Wayfarer is picking on poor Taylor. That is not the case. Anybody that shows up on a list as having knowledge, which is how Blake put it, having knowledge of this case, it is defense's job to defend their client, to make sure to contact all of those people, especially someone who has come up in the text messages described as a dragon that was assisting Blake in what she was doing. So we will know one way or another when and if her name appears on that list. Ryan famously was not deposed either. That doesn't mean he won't be called, because he was on her list. So we will know once and for all who they intend to call as witnesses. There are also other people who may not have been deposed that could end up, others that have not been deposed, some that were found later in discovery, that were found in some of the messages. It was kind of like, oh, what did you have to do with this? Something like that. There could be some surprises, and there could be some disappointments. Some we're expecting to see and we don't get to see. But either way, that will be an exciting document to get, that list, because it also includes a brief summary of the substance of what their testimony is going to be. So a lot of information on that list. And here's an example. And I chose this one because it has something that they mentioned. It mentioned whether or not they're going to be live or by some kind of recording or affidavit. And so that's listed here. And then it also said if they need translation. So this one does need. But you can see there's a summary both by plaintiff and by defendant, because they may have different things they want to question that witness for. Naturally, they're coming at each of these from a different angle. So they both list the summary of what they're going to elicit from that witness. So very, very exciting. I really, really look forward to that. Also exciting is the deposition testimony that is going to be offered. So there have been quite a few depositions, and those can make it to the trial, especially if they're concerned that something might show up differently. So there might need to be something impeached. We'll get to know in advance not only what that testimony will be, but the timestamps, so that we can know in advance. Also, counter designations and objections. This is the part I've told you about before. All of the good evidence that one side brings in, the other side will try to get it back out. And they have to do that with appropriate objections. So here's an example. So here is a witness, and then as you see all the timestamps there, and then we see where the defendants have said, no, not that, but how about this instead? And they have to put a reason if they're objecting based on a legal statute that has to go there. So that's what we see there. They didn't put them at the top, but they put them at the bottom, the federal rules of evidence. And so they will try to say, but it won't always be true. So this is the part where I think we're going to see lots and lots of fighting between the two sides, lots of disagreements that they're not able to resolve amongst themselves. And so we know what happens then. They have to bring it to the judge and say, we cannot do this. Please decide this for us. And he will have the ultimate say in the end. But let me see what this little bit. Yeah, they can put this information afterwards to explain what their objections are and why they're objecting, because there's just such a little spot in that little table. But yeah, look for this to be the most heated part of all of the pretrial filings. This is going to go, I feel, just like discovery went. Fighting, fighting, fighting. Because one thing is for certain, the way that Blake tried to hide and keep things sealed for so long just from us, she's going to want to keep that stuff hidden from the jury. You better believe it. So this is, I think, going to be the most heated part of everything. And I've been saying that for quite a while. Then we have, this is also very, very exciting, a list by each party of, yes, Van Zandt Van Sham could make this is where I expect Van Zandt Van Sham to be the star of the objections. But we'll have to wait and see. So a list by each party of exhibits to be offered in its case in chief, with one asterisk indicating exhibits to which no party objects on any ground. And then the objection should be noted. They have to put the federal rules of evidence. So that's something we haven't looked at a lot, but we're going to get real familiar with these, I'm afraid, because of all these objections that I think will be coming. They can't just say, we don't want that in there. They have to support it by these federal rules of evidence. And so we'll get to go through that, but I will not be at all surprised if those get a little twisted and overplayed and misapplied and all of that good stuff. If any party believes the court should rule on such objection in advance of trial, that party should indicate a notation to that effect. So I think there will be notations. We'll have to wait and see. So this is what that will look like. Not everybody's this neat, but usually it is in a table like this. So this is what I expect, where I expect to see, and Daphne got ahead of me. She's reading my mind in advance. This is where I expect to, if we're going to see Van Zandt, this is where I think it will be. If there are text messages or things like that were only gotten through that subpoena, I think this is where we'll see it. So as you can see, the name of it, this is the Bates stamp. If you remember the Bates stamps, that is the courts asked both sides at the very beginning to come up with a system for how each of these will be named and numbered, so that, because we know discovery can become a mountain of things, so that when one is referring to the other in things like this, the others can easily find it. Where if they each have their own separate, it can get really, really messy. So that is the Bates stamp we see in the second column. And we've seen, no, never mind that. I'm going to skip that. The exhibit list description. So we're going to get a chance to see what each of those things is. Everything's been unsealed now, and we've been pouring through that for weeks now. So we should have already seen everything in that list. Then the asterisk there is if there is no objection. So this makes it easy for the judge preparing for the trial to know which things are going to be issues, which things he might have to decide. So PL Demery Gray says, easy to find, just like the original Van Sham subpoena. That was not easy to find at all, was it? So, but I believe it will be in here. So exciting, exciting days. That takes us down to our next one, a statement of the damages. This also will be very, very exciting. We've already seen some of Blake's claims to see that she's asking for over $500 million in damages, which are absolutely ridiculous. But a statement of the damages claimed, any other relief sought, we know that she is requesting 47.1, which is treble damages. Other people early on mistakenly described that as like triple attorney's fees. It is not. It is actual, it is damages, which is separate. So any of that relief, she's also asked for sanctions. So all of that, if the judge doesn't say no sanctions, if he doesn't rule on 47.1 before the trial, those all need to be listed here, including the manner and method used to calculate. So that will be fun too. If Blake is still asking for, what was it? It's like over 600 million, right? Isn't it something like that? It's been a while since I saw the number, and it was so unbelievable that my brain probably couldn't hold on to it very well. But she has to show how she came to that conclusion. We've seen some of the expert reports, but this will be much more concise. This will be like something like this. So we see the list on the left under totals, where they come from, then the amounts, and then the next page showing the methodology. How did you come up with this number? Okay, thank you, Rose, as well. I figured some of you would know. So between 600 to 700, and so $750 million. Ridiculous. Those people want to be billionaires so bad. And we've heard them over and over again stress about Steve Sarowitz being a billionaire. They're funded by a billionaire. And it's so funny because when we started, I think his net worth was like 1.2 billion, and now it's over 2. So all that crying, it's just ricocheting all around. Then the final one is a statement of whether the parties consent to less than a unanimous verdict. What does that mean? Most of us watch criminal trials. We know with those, it has to be unanimous. If there's one juror that does not agree, we end up with a hung jury, a mistrial, a do-over. It's not the same in civil court. It does not have to be unanimous. It does not have to be 12. So what does it mean when they consent to a less than unanimous? That means it can be 9 or 10 out of 12 if there are 12. There can be as few as 6. So it would be like 5 out of 6. But this is something that has to be decided in advance. What they're going to require in order for it to be considered a win. And then, so we got through that section, and now we get to the actual, what are these actual filings? So here he has a split because he covers both criminal and civil. And so some of these, and he covers both jury and non-jury. So he distinguishes something that is for all cases and some that are in as one of those types of cases that he oversees. So in all cases, the first thing, it requires a motion addressing any evidentiary issues. I think there will be some, or other matters which should be resolved in limine. Well, you've heard me talk about that. I'm going to show you what that all means. And he wants that filed in a single memorandum of law. So maybe they have multiple issues. He does not want a memorandum of law for every single issue. He wants one for no matter how many there are. He does not want to be bombarded at the very end with a bunch of things to read and decide. In all cases as well, sorry, he doesn't want any other kind of memorandum. Like, that's it. You can give me this one. Anything else, you have to ask my permission first. We have seen in this case specifically situations where Ezra filed something when, all of these motions we've seen, there's a time that they're due and there's a certain number of them. So for example, one gets to be filed, then the other side gets to respond to it, to oppose it, and then the original filer gets to reply to that opposition. So all of that is all decided. It's been decided early on. It's also in this document of his with his individual practices. Some of it is standard in every court. And but we have seen where there wasn't a file due, but Ezra filed one anyway. Do you guys remember that? And then he brought that to her attention and allowed Wayfarer to respond if they wanted to, since once somebody does it when they're not supposed to, the other side gets granted permission to do it. Sorry, I got a drink. Hold on. Okay, sorry about that. Okay. Let me see. I do have. Okay, so this was the evidentiary issues that they were to file if they had. And we see that here. So it starts with the plaintiff, just like before. And so it says plaintiffs respectfully request and defendant consents that the court preclude the presentation of argument or introduction of evidence that, and then they give a list, and sometimes it's a list that they've all agreed on, and then other times it's not. More often than not, it is something they do not agree on. And welcome back, Christina. Sorry, they were out there driving. If you have stuff to do, don't worry. I think everybody's behaving. So if you've got to do something, don't feel bad to leave. So that is what these motions in limine will be all about, trying to preclude evidence from the other side and trying to fight for the evidence from your side. So this is one example of that. Then what comes next, and we saw in the order that, let me flip back and see if I can see it, and we don't have to, I'm sorry, I'm going to have to flip back through here. There's quite a few. Wait, I think I can go back a better way to, yeah. So they have a week. So the pretrial filings will go first. Then the opposition to those motions in limine will be 1 week later. And then another week for the oppositions to the Daubert motions, if any. All right, let me get back to this. Where was I? Oh, I was further ahead than I thought. Okay, so this is an example. So that last one was the original motion in limine, and then this one is the opposition. And so that's what this looks like. So they state each argument that they have about that motion, step by step, why they think they're wrong to request that. And then we have the judge's order, what he thinks. So this one, I was able to find one that was from Judge Liman. I almost called him Dr. Liman for some reason. So, and this is how it will go. So he says each move in limine in advance of the bench trial scheduled for January 15th, 2025 to exclude evidence proposed to be offered by the other party. And this is very common. Both motions are denied. So just like happened with the great unsealing, he's like, no, It's gonna be shown. So he very well could decide, hey, there's no reason to rule this out. You did not give me a sound legal reason why it should be ruled out, and so tough luck, both of you. It's all going in. Then he explains it. He says the purpose of this motion is to aid the trial process by enabling the court to rule in advance of trial on the relevance of certain forecasted evidence as to issues that are definitely set for trial without lengthy argument at or interruption of the trial. So if they put this off at the end and they haven't decided it and somebody brings it up and the other counsel wants to object to it, then they got to dismiss the jury, then they got to have a little minor hearing about it, a little fight there, and then it's very, very disruptive. And you don't want to spend a lot of time. Not only are the judges extremely busy, and so their time is very, very cramped and well spoken for the plaintiff and the defense. They're paying a huge amount of money, especially in a case like this. They have very top tier attorney firms, law firms, and they're huge. They've got multiple attorneys from each firm, especially on Blake's side. They are all going to show up for their time in court, and that is going to be outrageous. So it's in everybody's interest, except for, of course, the attorneys who are getting paid for it to be long, to try to keep this short. So it's all about that, but mostly the judge. He's got to keep his schedule. He's got a lot of other cases, a lot of other motions that he has to rule on, a lot of orders he's got to relegate, lots of things he's got to do. So he doesn't want to spend a lot of time fighting over this stuff once trial has already begun. So they really want this done before. Then he says the trial court should exclude evidence on a motion in limine only when the evidence is clearly inadmissible on all potential grounds. So it looks like he keeps a pretty tight rein on that. And as I mentioned earlier, these are all decided upon by the federal rules of evidence. So if those do not support the argument, no matter how many of them you've quoted as reasons, he will say, sorry, it's all going in. Or it could be split. Like in this case, it was both, all of it. But in other cases, he could go through and say, well, this one meets the standard and the rest of these don't. It could be a nice little mix. But he's going to have fun with, again, all of that Van Zandt stuff, because that's a big deal. It's not just a big deal for this case, but in New York, it looks like this kind of thing is happening. So many attorneys, some of the Blake attorneys who claim to be New York attorneys, are saying, oh, this isn't a problem. This is okay in New York. Well, his decision on that is going to be huge. If that does get brought to his attention, that's going to have a lot of effect in New York state courts. And a while back, I don't know if you've all seen it or not, a case like this happened in South Carolina. It involved Representative Nancy Mace, in fact, and someone did exactly the same thing that Manat did. It wasn't for just a subpoena. In that case, it was a subpoena for a deposition. And they actually held at least one, if not two, depositions. And they did it in the same way by filing a sham lawsuit, getting this sham subpoena and trying to keep it hidden, but it came out, and those attorneys were sanctioned. They were sanctioned a good amount of money, and that is out there, public record. This is not allowed. You cannot do that. So if they do present that to him, his decision is it's going to be a matter of record. And either way he goes with it, they can appeal if he says, oh, it's okay, but I don't think he's gonna. As I mentioned, he covered a Doe case just last summer. He did it the appropriate way, the way that I have said from the time I heard that there was a Doe lawsuit. I started talking about what the appropriate procedure is for them. And even at that time, there were even some non-pro Blakers who were saying I was wrong. But the way that he presided over when a Doe case came into his court is exactly the way I said it goes, because I got it directly from the rules. So, and from case law. And that is the way he presided over it. So this will be a very, very super duper interesting part of all of this. And I really, really, really hope that Wayfarer brings it up, because that will be the most exciting voir dire I have ever seen. Same. Oh, I don't hate her. I don't even, I mean, I know she's hated. I'm not a political person. I don't even know why people hate her. I don't know anything about her or what she stands for. But yes, what was done to her, whether you like her or not, was disgusting. And it was a loophole sham lawsuit. And yes, very terrifying. From the first day I talked about, when I found, we didn't know the Van Zandt subpoena yet. We didn't know where the subpoena came from. We knew there was Doe, and we just like I went off on that. But that was from the very first video I made about a Doe lawsuit, that was my point, that these things can be used and they can bring really, really a lot of harm. There's a lot of potential for harm, namely, I feel, harm to women, because stalking victims, by and large, are women. If someone can go and do something like this, and do this little sham lawsuit that you have no idea is happening, nobody informs you that it's happening, you don't get a chance to quash it, that is so wrong. And by and large, that would be used against women, as it was in this case. Look at what it did to Jen Abel. And I have screenshots of her. I haven't brought it up yet, because it still makes me cry when I try to read it. And I don't want to do that. I want to be able to talk about it. But she posted just the other day on her Instagram about how she feels about what was done to her. And I mean, if you haven't seen it, you'll cry too. Or if you have seen it, I'm sure you did, because it's just, to put yourself in her shoes about what happened to her is so absolutely awful. And another thing, what do we have a lot? We have a lot of wives who have attempted to escape a very abusive husband. They're in hiding. And what can he do? He's got her social security number, her birth date. He's got a lot of information on her already. He could go find an unscrupulous lawyer like Blake did and say, I need to find this, and get a subpoena and find her. Because the kinds of things that are happening, I have been talking on my platform since long before the Blake Lively case about the fact that 3 women, and now it's more than 3, every day are killed by a partner or an ex-partner. And oftentimes it's when she's ready to leave and they just can't handle it. They'd rather see her no longer on this earth than walk away from them. And so that is a very dangerous time. It also happens, the number one cause of death for pregnant women now is no longer things like eclampsia or hemorrhaging like it used to be. It is now death by your partner, which is the sickest, saddest thing I can think of right now. Is that's the number one, and you could look it up, the number one leading cause of death, and I've said this on my channel so many times, of pregnant women is now death by their partner. So another thing you could probably all recite it now if you follow me long enough, is oh no, what I was going to say, now what started to happen, I've seen 2, I think just in this year, women who were not only, they had already left, they had already divorced, but they were remarried. I'm not talking a short amount of time. I'm talking they've already had like 2 kids by their new husband, and their ex has hunted them down. Don't know what got, in one case, I think it was something to do with child support. He didn't want to pay the child support, and there was a new ruling in it. He comes to her home where she lives with her new husband of several years and kills her. It's insane. There have been 2 cases of that. One, I believe the husband, they had the security system, probably because of the ex. They had cameras inside the house, and he watched in horror, completely helpless. He watched that happen to his wife. So this is why this kind of sham lawsuit must be defeated in court. We must have a court say, you cannot do this. And if you do this, there will be consequences. Because there is no way in this world that this Van Zandt was the first time that was ever used. I promise you. There's no way that was the first time, just with this law firm alone, let alone, I mean, somebody came up with this idea, and there were enough attorneys out there saying, oh, that's a clever loophole. That is clever lawyering. Oh, look at that. I'm going to put this in my own practice. That just those shocking, alarming comments alone tell us that we need absolute law and statutes and whatever else we can do to stop this from ever happening again. But anyway, little Cassidy side quest there for you again. I I said I was going to get a bell to like ring it and go Cassidy side quest because I have those all too often. But anyway, yes. So this may be the moment we've all been waiting for, where Van Zandt finally gets called to court. All right. So of these filings, what are they? We start off with a joint request to charge. It is also called jury instructions. And so what this is that for each cause of action, we know that there are things in there that we might not be familiar with. The jurors will be people just like us. They may not know what that means. They're going to get these things explained to them. They will also have things explained to them about a background of the case, things that have already been decided about the case, and then how they're going to come to a verdict of it. And now in this case, we won't have guilty and not guilty. That's only for criminal trials. So this is just, did the guys do what she said they did? And they will determine whether or not they feel there's enough evidence to support her claim. And if so, should there be damages? And if so, how much? So that's what a lot of this is, just information for the jurors so they know fully what their job is. Sorry, let me go back to this because it was also joint proposed verdict forms and joint proposed voir dire questions. And this, again, is probably another thing where they're not going to agree. And so if they cannot agree, of course, and they have to say why they disagree, and then, of course, bring it to the judge. Anything that needs brought to the judge probably will, just from the history of this case, of very, very troublesome plaintiffs, shall we say, and her attorneys. But so I fully expect there to be lots and lots and lots of fights. All right, then this is the joint proposed verdict form. So it's, to me, I think these should be longer because jurors, like I said, they have no background in this kind of stuff. So it's all new to them. So this explains what they need to ask themselves to determine whether or not Wayfarer should be held accountable for the claims that Blake has brought. So this is for each one. And then if there are more than one defendant, so in this case, that list is going to be long because we have, that's if nothing gets eliminated. We have Justin has claims against him. We have Jamie has claims against him. We have Wayfarer. We have It Ends With Us. We have Jen Abel, Melissa Nathan. We no longer have Jed Wallace. But so for each of the defendants that will remain, they will determine on here yes or no. So that's what these look like. We'll get to see these. These are all due on the 3rd. So do you see what I mean? It's going to be really exciting when we get all of those. And then these are the voir dire questions. I talked about this earlier when it was talking about the names of people and places. And I was suggesting that this might be what that is for. So they get to ask each of the prospective jurors about any connection they may have to the case. And then there can be other questions too, just aimed at qualities they want in a specific juror or don't want. I mean, it can't get too crazy. I think the total was like 4 pages of this document, but I just put these up here as a little sample for you. They want to know about a person's past with lawsuits. That's a really good question. If someone has filed a bunch of lawsuits, you probably don't want them on the jury. So that's just a real quick little sample of what it will look like. And that will have a little information for us, but not quite as telling as what some of this other stuff will be. And then I also found an old order coming from Judge Liman specifically. And this was, what was this? Let me look at it again. Oh, yeah. This is what happens if you don't put your paperwork in correctly. That's what happened with this case. And you get to see how important it is that all of your I's are dotted and all of your T's are crossed. Because, as he says, the court ordered the parties, including intervener, to submit joint pretrial orders as well as other submissions by 5 p.m. today. And it talks about plaintiff did it on time, but counsel for defendant failed to make himself available to a meet and confer. Instead, counsel for defendant emailed Chambers his exhibit list, and at 4:57, so 3 minutes before the deadline, counsel for defendant emailed Chambers what he represented were joint pretrial orders agreed to by all parties in both matters. But so now there's two. There's only supposed to be one. It's supposed to be joint, but both sides put them in. And not only that, in the defense exhibit list, or in their order, they made reference to a joint exhibit list, but they did not attach it. Nothing was filed on the docket. And here's what he says. This is how serious it is to get this stuff right. The court would be within its prerogative to preclude defendant from offering exhibits that are not contained in the joint pretrial orders filed by plaintiffs. So he's saying, I could sit here and say, you missed your chance to submit exhibits, which would absolutely destroy their case. They would have no exhibits. That is a big deal. But counsel for plaintiffs have not asked for this relief. You can bet they were like, oh man, why didn't we ask? We could have handled it. But however, and assuming defendant complies with this order, would not be entitled to it. So they missed out too. They missed out on that chance. So both sides got to be watching this. They got to be looking at not only what they submit, but what the other side submits. And if the other side misses something, they need to inform the court so that, I mean, it could ultimately destroy the other person's case before it even goes to trial. So he says the court cannot go to trial with two competing joint pretrial orders. So he gives them until 9:30 that same night, so just a few extra hours, to serve plaintiffs and intervener by email to all counsel the proposed exhibit list, as well as any edits to the joint pretrial orders submitted by plaintiffs. Failure to do so will result in waiver of the right to submit exhibits not otherwise included in the filed joint pretrial orders. So this could have been devastating to them simply because they forgot to attach their exhibit list. So it's really, really important that they all, and I really hope, because we've had a couple of misfiles in this case, so I really, really hope that Wayfarer is on it with this, because Blake's attorneys will be sitting there just poised and ready to pounce if they miss anything. Okay, so yeah, that is that. So it's exciting news. It's not news that says, oh, he's coming soon with his dispositive motion orders. It could be. It could be. But then again, it might have nothing to do with that. It might just be like, well, you agreed on a week, one side wants more, but I don't have to do that, so it's a week. And he could simply say, I'm busy, it's going to take me too long, just prepare your entire cases and be ready for anything. So there's really no indication by this. I'd like to think that it means, since he only gave them a week, I would like to think that it means it's coming soon, but we have no credible reason to say one way or another what it means. So I'm going to close tonight with in a bit of a rush so I can go brush my teeth and gargle some mouthwash and get this awful, awful taste out of my mouth, and look up and see like what I have ingested this evening. Anyway, I'm sure it's nothing serious. That stuff is probably all tested in case, well, usually kids, not grown-ups, but in case we do stupid stuff like this. So anyway, thank you guys so much for joining me tonight. I hope this has given you some information about what it is that we're looking for to be filed and which parts of it are going to be so exciting once we get them. And we have less than a month because it's April 3rd is the deadline. And that sometimes things have been filed before the deadline. So that could happen too. So yeah, definitely. This is a record shortest stream. It really is, of my lives for sure. Even the ones that I've promised are going to be short. So, but I still didn't manage to keep it under an hour. But anyway, yeah, I hope this all helps you know what to look for and be excited with me about some of the things we're going to see very, very soon. Have a wonderful, what is today, Wednesday? Have a wonderful Wednesday night, and hope to see you soon.